On this episode of Real Estate Insiders Unfiltered, we talk about the verdict, rules that we should be putting in place right now, the copycat lawsuits, whether NAR should settle or appeal. Great show. Tune in, everyone. You talk about it privately. We talk about it publicly. This is the Real Estate Insiders Unfiltered podcast. Welcome again to the Real Estate Insiders Unfiltered podcast. I'm your host, James Dwiggins, along with my co-host, Keith Robinson, a.k.a. Crazy Uncle Keith.
Yes, sir.
We have a repeat guest. Tell everybody about the fun conversation we just had.
We had Ed Zorn on again. He is the Vice President and General Counsel for CRMLS. We had him on previously on episode 27, where we were talking about the settlements when they first dropped. This time we dig in on the verdict, now that we have one, sort of what the next steps are, copycat lawsuits, some pontification on where it all will go, and some of the long tail effects we hope we can avoid.
And some rules that he thinks we should be putting in place, which I think was a good part of the conversation. So
Correct. So it's good to be informed. Put it in your ears, kids. Ed is literally the smartest person James and I know on this topic, and we were thankful to have him on again.
Tune in. Ed, welcome back to the show. Our first repeat guest back on the pod. You have the honors of that.
At this point, we should just have him recurring monthly until all this is done.
I'm not sure your listeners would appreciate that, but I do appreciate the opportunity to come back and share some thoughts and maybe answer some questions that you guys have been getting.
Well, if we do it monthly, he'll bill us. So
yeah, never mind. That was a terrible idea.
That was a terrible idea, Keith.
I take it back.
We go on retainer.
So real quick, and we'll do this fast because we want to dive into a lot of stuff regarding the lawsuits. So everybody knows Ed Zorn, Vice President, General Counsel for CRMLS, the largest multiple listed service in the United States. Ed, real quick, just quick background on you, and then we'll dive into all the juicy stuff. So
sure. Yeah, I've been with the California Regional MLS for about 8 years. And prior to that, I represent a lot of local realtor associations, brokers, and developers. As an attorney, I've also been a realtor for 20 years, running my own small real estate firm. I also helped manage a 3-office franchisee across a couple of markets with a lot of commercial experience. And then prior to all that, I spent about 15 years as a plaintiff's trial attorney doing predominantly real estate and construction defect litigation in Southern California. So
basically, Ed wears a lot of hats, and what makes him unique is this experience of not only obviously being a lawyer and involved in the industry, but also doing what everybody on this who listens to this pod does every day. All right, so we want to spend as much time as we can while we got you. We had you on prior to the trial, and you are the lawyer Yoda of figuring out exactly what was going to happen, because everything you said was going to happen actually happened. So verdict is in. Everyone knows what the verdict is. I think let's just give just a quick 30 seconds on where we're at in this process, what happens next with injunctive relief, and then we'll have a million more questions after that. So just kind of set us up on where we are, what's likely going to happen next in this process, and then we'll talk about the copycat suits and other things as well. So
sure. So where we are, obviously everyone knows that the verdict has come in from the jury. Under some federal local rules, that verdict gets turned into a judgment by the clerk of the court. Not unusual. What the judge did recently is they vacated the judgment. And that's important because the judgment is the date that triggers a lot of other things like your time frame for appeals and things. So he vacated the judgment and set a schedule for briefing for any post-trial motions. Now, we fully anticipate NAR will bring a motion for a new trial to vacate the verdict. These are very normal motions that defendants bring. They're very rarely granted, so we'll see what kind of arguments that NAR can come up with and see if any of those are persuasive to the court. But in all likelihood, he'll move forward with a judgment. Another motion that can happen in this period of time is going to be a potential injunction from the plaintiff. Now, he doesn't have to bring an injunction. They asked for it in the complaint, but they did not certify a separate injunction class like they have in some other cases. But we do anticipate And the buzz in the industry is that he will bring some kind of motion for an injunction. And remember, what an injunction means is it's asking the court to issue some kind of order for someone to not do something or to do something. And we also know at this point that the plaintiff's attorney has in fact been in communication with the Department of Justice. And so we would expect some of the vision or ideas of the Department of Justice maybe to also influence maybe some of the language of a new rule that we're all going to have to live by in the upcoming months in this injunction process.
What does that look like? What do you think that, let's just stop there for a second. What do you think that injunction looks like? What do you think they're going to request?
My best estimate, based on taking into account things that we know about what the DOJ's complaints have been in the past, some of their filings in NoSelect, I believe that you're going to see an injunction that orders the National Association of Realtors to issue a rule that forbids MLSs from including a field in the MLS database that is a unilateral offer of compensation coming from the listing broker.
In essence, that would decouple it. At the moment, the judge, I don't know if it's signed or they put some cool Game of Thrones-y wax stamp on it. That would be rad too. But when that goes into effect, the changes start then, correct?
Correct. I would anticipate that if the court's going down that road, that NAR would bring in some kind of evidence to remind the judge that, hey, this kind of change means we have to do things like change forms. Right? Listing agreement forms are going to have to change. Residential purchase agreement forms may need to change so as to accommodate the payment of commissions, so that this can't just happen instantaneously. We're also going to have existing contracts that still have to go through their life.
Active listing agreements,
so I would assume that there would be some kind of period of time that the judge would build in for the changes to kind of take effect. And the nuances of that change also matter, right? So does the judge say just listing brokers are prohibited from, offering compensation, or does that include sellers directly? Right? In other words, you can't have any field at all, or is it only listing brokers that are prohibited? That's a nuance that can happen. There's also another nuance of something that's really important, which is, what about today? For those of you out there that are actually, in people's living rooms doing deals, how many of you are negotiating like a 2-1 buy down on a loan right now, or doing some other kind of buy down points to try to encourage the buyer? And this is very beneficial for buyers, by the way.
Yeah.
Or other credits for flooring or roof repairs or deck repairs. I list those things because those are all things I have personally handled and included in offers that I have made. Right. So how does a seller using the multiple listing service still convey the willingness to offer some of those credits that are important in a transaction that would incentivize, again, the buyer directly, not the buyer's agent, but the buyer directly, so that I, as a buyer's agent, know how to fashion that offer? In other words, what concessions are already packed in that list price that the seller picked? Right? There's a very real important opportunity that we don't want to kind of throw the baby out with the bathwater on. And so I think, guys, that's some of the nuances that are going to have to go in front of the court for consideration in what's going to happen on what does this order look like.
One other big point. Let me just put a bow on this real quick.
Yep,
so this is the answer to the NAR is going to appeal and this will be settled in 5 years crowd, right? Like that's a theoretical possibility. Of course, it's not a 0% that will happen, but it is also not a 0%. And I think all three of us think it's a much more likely percentage that if an injunction comes along, that ends this whole nothing's going to change for years because NAR is going to appeal, correct?
So, yes, I would expect that NAR would request that the court stay the injunction. In other words, they'll ask the court, hey, let's not move forward with the injunction yet because we might win on appeal.
Right.
I personally don't think the judge would issue such an order. And the reason is a couple of reasons for that. One, NAR lost. And they didn't kind of lose. They didn't kind of barely lose.
No, they lost bad.
Right? Yeah. The jury was out for an hour.
An hour and a half. Come on.
It's actually 2.5, but the point's the same. So
it's actually an hour, right?
Is it an hour?
Yeah, is it really?
So if you guys remember, I've been a jury foreman before. Okay, so I've been a juror. It takes a solid half hour to figure out who's your foreman going to be. What do I do with this stack of paper? How does this work? And then they asked for the damage request, right? They had a question to the judge. Hey, how do we figure out damages at 1 hour and 38 minutes?
You're making me want to drink, Ed, by the way.
Okay, so let's just say it wasn't a close race, right? And I think the judge may look at that, right? It was an overwhelming win for the plaintiff. And as a result, I think the judge can say, hey, look, your chances of appeal while you may win on a technical argument, and I think NAR could win on appeal, guys. I do think there's a path for them to win.
Yep.
But I don't know if a judge says, we're going to wait 4 or 5 years and let another $2 billion of damages occur in the meantime while we wait. If you're the judge, would you do that?
Right. No.
Or would you protect the people who already won? Right.
Well, and I want to make sure we cover this because Keith and I have been very outwardly spoken about this needs to settle for a whole, also the pressure of these, copycat suits. We'll get to that in a second. I just want to be clear. I read that this injunctive relief has a schedule, right? It's not, the decision won't be made for several months. Or is that something completely different that I was reading about? So I'm clear on that.
The schedule that's different is the motions. So the judge has vacated the current clerk's judgment, and he set a schedule of times for the different parties to file any post-verdict motions.
Okay.
One of those motions could be, and I want to stress, it's a could be. Again, the plaintiff can decide not to file a motion for an injunction, right? But there's an opportunity here for NAR and the plaintiff to maybe get together. You talk about a settlement. I think you're right, James. I think that's the proper road that we should go down, and realize you could have 2 different settlements. You could have one settlement that focuses on the rule, what's going to happen next for us in the industry. That could be one thing, and that can be separate and distinct from the appeal and the settlement and issues with regard to money.
Can I'm just had this, I'm going to sound like probably an idiot even bringing this up because I'm not a lawyer, but isn't there an opportunity here for Anywhere and Remax? Well, I guess let me ask this question differently. If they ask for an injunction, is there a way to separate the 2 people that have already settled from any of those things? Or would it applies to everybody regardless? I guess I'm trying to say, is there a move for Anywhere and Remax to basically state things have to occur in order for us to stay with the settlement? Yeah, does that make sense what I'm asking? No.
When you go through the settlement agreements are all about money and conduct that Anywhere and Remax have some influence or control over, right? Okay. In terms of their franchise agreements, things, how they do training, these kind of things. They have zero power over what an NAR rule is going to be.
Yeah. Okay.
Right. And so those things are really not connected.
So whatever happens applies to them too, though. So whatever the injunctive, so they're in the same boat. If basically whatever applies to the whole industry or NAR applies to everybody regardless. Is that a minus the money portion and the rules that they agreed to in the settlement?
Specific to transacting residential real estate.
Correct. Yeah, there's not going to be one set of rules for Remax and Anywhere and a completely different set of rules for others.
That's what I'm asking.
I don't see that happening now. That being said, Anywhere and Remax are still parties in the lawsuit. They still get to stand inside of the courtroom, and they could still exert some kind of influence or opinions with regard to what the rule should be, right? Nothing stops them from exerting some arguments to advance a particular rule or oppose a certain rule that may impact them, in the case. So they still have that standing that's different than others, but there will not be like a Remax rule and a separate rule for others, as an example.
Okay. All right. Now, this is an important one because I want to make sure that we get this right for everyone to hear. So the judge has not decided the total damages amount yet. Has he applied the treble damages, or that has not been?
He has not done that yet. That will be part of a judgment. So where we're at right now is we have a verdict from a jury. For the $1.78 billion. And now what's going to happen is that verdict will be converted into a judgment from the court. But before he issues that judgment, the court is going to hear some motions from the various parties before he produces that judgment, right?
Okay.
So that's
which is where he can decide to do treble damages at the same time.
Correct.
Is that correct? Okay. Now, so there's my question. $1.78 billion currently. Let's just use the bottom number. That's what we know we're there. In order to file the appeal, the defendants have to post the bond in order to cover that. Is that correct?
So some misinformation swirling all around about this bond. Okay. So remember what the judge's purpose for the bond is. The idea here is plaintiffs have won. They got an award for $1.78 billion, right? So on the one hand, the judge is going to weigh, and we lawyers and judges talk about weighing all the time, right? We weigh evidence, and that's what the judge is going to do here. So on the one hand, protect the plaintiff's $1.78 million or billion, excuse me. We wish it was 1.7. On the other hand, the judge also has to take into account the reality that maybe the defendants will win on appeal. So you don't want to set the bond at such a number that you just bankrupt everybody and everybody loses by default anyway, because you set the bond at such a high number that there's no reason to even appeal, right? So he's got to balance these two things. What people are confusing is in the code, you're entitled to an automatic stay of the judgment, execution of the judgment on appeal if you post a bond in the full amount, meaning the judge has no choice. If you post the full amount plus lawyer fees plus interest on that amount, the judge automatically has to issue the stay. On the flip side, you can ask the judge for a different number. And the judge can then say, hey, if you pay X dollars to the court, then that is enough for us to protect the plaintiff based on me, judge, weighing these issues. And I will stay the proceedings if you put in and post this amount. So I think some people are confusing that the only way it gets stayed is if they post the full amount. That's not the case. The judge can lower that amount if he wants, but he doesn't have to.
But it's up to the judge to make that choice.
Yes, that will be the court's weighing of those two interests, the plaintiff getting money to make sure people don't, bleed the money away, versus taking care of the defendants and making sure that there's still a reason they can appeal without, trying to throw them into full bankruptcy.
Traditionally, what percentage have you seen that be when the judge makes a decision?
That is truly case by case. That is, there are actually a number of states around the country that have actually set a max, right? There are a number of states that have like a 50 million or 100 million max for a bond, kind of recognizing the fact that there's such a large number of money that you're basically, if you set the bond number too high,
it's
you've just ended the company.
There really is no ability for appeal.
Right? Because I mean, there's no, am I off on this? But there is no way, at least for, we don't know Warren Buffett certainly, but let's just hypothetically say they're not going to dump that kind of money in, that they're going to be able to post a bond that large. They'd have to have a reduced amount in order to appeal. Is that a fair assessment?
I don't have any thinking that the bond is going to be, for each of these defendants, is going to be, totaling, 1.8 billion. I don't think that's going to happen. Right. I think what a good judge is going to do is they're going to look at the cash equivalents, maybe equity in real estate, some discounted value, maybe on some stock holdings that you could pledge, that you could then kind of secure some money against. I think that's what you're really going to see, not the full value of the company, right? And honestly, the court can even be informed a little bit by these settlements, right? What were these settlements at? They were at about 50% of their cash and cash equivalents, right? So is that, is that maybe something that he can consider? These are all on the table for the court to, again, he's going to balance these interests against one another to try to make the playing field as fair as possible, so that the defendants who want to appeal still have a reason to appeal without them being wiped away because the bond amount is so high. It's just going to wipe them out, right?
Okay.
So,
all right. So let's talk about appeal and settlement. There's obviously two camps on this. Keith and I are very much in the settlement camp. We'll explain in a minute, but let's go down that road. Appeal could take forever. I'm making that up, but like it's years and years and years. Like it could be years and years and years, but then they're spending a ton of money on lawyers. Am I correct? Let's start there. Let's do a quick analysis on that, and then I want to talk about settlement and why.
Sure. Okay, so appeal. Remember a couple things. When you do an appeal of a case, what you're appealing are things the judge did. You do not get to appeal the facts that the jury determined. Okay? Now, you can appeal that the jury was inappropriate in making a decision because they didn't have enough facts in front of them, or the facts that they decided didn't support the judgment or the verdict that they rendered. And I think that's the argument that NAR is going to go down. But you're really looking at things or errors that the court made that may have affected the outcome. In this case, what we're talking about are a couple things. The idea that it's a per se standard versus rule of reason. We talked a lot about that in the previous episode. Go ahead and listen to that if you want what those levels are. Another one that I think has some legs for NAR, and that is there's a case called Illinois Brick, and it stands for the proposition in antitrust that you have to be a direct purchaser of services from one of the defendants. So one of the defendants has to be the person you interacted with to get these services. Now, at the trial, NAR argued that the actual payment made to the buyer's agent was from the listing broker, not the seller. So as a matter of law, the seller can't be damaged because it would be, if anyone overpaid, it would be the listing broker. Now, some challenges with that argument are every single closing statement presented in the case had it on the seller's side, right? Seller paying both agents. I think there may have been some testimony from a couple of the corporate defendants that made reference to the quote seller paying the buyer's agent, right? So again, remember, this is all about weighing and balancing evidence, right? So there was evidence that the seller paid. I think the best piece of evidence of why this is a hard one to win, as a broker, if I'm the one who paid the buyer's agent, that means I should be booking inside of my company the full value that was received. And then I need to send 1099s out to everybody for what I expensed as a cost with me paying them. So that's certainly possible. But is that how transactions look and actually function out in the real world? Probably not. I think NAR has a stronger argument on the indirect purchaser issue on appeal. And they brought this up in their trial brief, I think, in a very good way, so they can appeal on this ground. And that is, who did the plaintiffs buy services from? No one entered into a listing agreement with the National Association of Realtors. And no one entered into a listing agreement with Keller Williams Corporate or Berkshire Hathaway Home Services Corporate. They entered into relationships with individual licensees kind of down the chain. So where's your direct purchaser? Right? So that's a scenario that could have some legs and could help NAR, win on the money aspect of this case. Now, that kind of dovetails us into the copycats, where they sued direct brokers in some of these copycats, and that gets rid of that argument, right? So it doesn't really solve the overall problem. It just
let's come to that. I want to put a pin in that for just a second. So NAR appeals, they go through this process and they try to make their case and win. And to be clear, just for full disclosure, Keith and I are still massive fans of NAR winning these cases. Clear about that.
We all
would be great.
We all are. Yeah.
NAR wins all the cases, correct.
This is, I think, is a T into this. Settlement is essentially, this other option. As we talked about in the previous pod, and you guys can go listen to this one. We're not going to go rehash it again. It's obvious that the plaintiffs they have interest in settling. They've already done it twice, and all the lawyers and plaintiffs were in the same room from all the cases in order to do that. So again, go to episode whatever it is to listen to that. What I find this is difficult right now, and this is a tie-in, the copycat lawsuits are happening. I want to cover those. but they're suing everybody else to get more people involved. I think strategy, and you tell me, you're a lawyer, but it's to get more people to put pressure on potential settlement. They're suing everybody at this point, not to mention that they have precedence with the case. But what I worry about is that if NAR doesn't settle, then all of these other companies start cutting deals like, Remax and Anywhere. And then NAR doesn't have a membership to settle with. It's a bold statement, but I'm directly saying that intentionally because, these large companies have been named, they start cutting deals. And if NAR needs to get everybody together to do something, they won't have it, right? Because they could say, well, we've already settled it out. You don't need to be part of NAR settlement. So am I on the right track here as a potential problem?
That is a potential impact with the broadening of the copycats. That makes it more complicated. There's no question about it, right? Settling 3 seller cases, which is what we had before this trial started, is always going to be easier than settling 5 or 6. Now, keep in mind with some copycats, a couple things. One, it's lawyers racing into their position to get named to get a check, okay? Remember that with the Gibson case, which is the first one that was filed right after this verdict came out by the same plaintiff's attorney for a nationwide class, right? What that means is all of these other copycats, the members that they're suing for damages to sellers are already in the Gibson class. Right. So you have overarching cases that will in all likelihood be consolidated. And then it will be for the court and the plaintiff lawyers to fight out later the pecking order of lawyers, right? So that's one aspect of these copycats. People are trying to get their case in so I can be in that pecking order.
This is the ambulance chasing comment that people make. Is that a... I'm sorry.
I had this side of me that goes, if you've been injured,
I get it. I'm razzing you.
Right? Yeah. So, but yes, that's what's happening.
If there was a settlement, does that clean out all of these copycat lawsuits or not?
It can. Now, it becomes a little more complicated though now.
Right.
Because one of the other things that's happening, what you're starting to see, is they're suing fresh new defendants. Mm-hmm. Why? Who in the right mind is going to sue NAR? They're just subject to a $1.78 billion judgment.
They're out of money, right? They're out of money.
Yeah, they're not going to have anything by the time I come out of the courthouse.
Right.
Right. So now they're looking for fresh money. But could NAR effectuate a settlement that covers the whole country, covers all MLSs, associations, and all brokerage firms? Absolutely. They could do that. It just you need a place where all of those various plaintiff attorneys are in the room and say, yes, I agree that this amount of money that comes from NAR, and NAR can still be the funneling mechanism to do that. And James, maybe this is, and I'm just talking off the top of my head without thinking, you just asked the question, right? If I put my mediator hat on to cover my bald head, which is one of those things I used to do, I could see a scenario where this could encourage some of these companies to stay engaged with NAR, right? Yeah. That if NAR fashions a settlement and it covers realtors,
period,
right? That's who that's going to cover.
Yeah.
Because that's going to be a decent sized number, right? Mm-hmm. I would think that, and brokers could help here by saying, hey, how much are you guys willing to pay? Because if this is truly what has happened, that some sellers have been damaged by a conspiracy of the industry, where's the money? The money is not being held by NAR. The money's not being held by companies like yours.
It's not being held by brokers either, by the way. Yeah, it's the agents. That's the irony of it. Agents think the brokers have all the money. They don't. Look at your splits.
It's individual agents. So the argument would be, at some point to resolve the case, should individual agents participate in the contribution to that? I argue, and you guys know this when I've argued that it was a case that could be settled before, my argument is yes, that if that's where the damaged money is sitting, then those individual agents should participate. And that would actually, I would argue, James, encourage people to stay with NAR if it's under that umbrella that they receive the the releases and things necessary by contributing. And you spread that number out over 1.6 million realtors, it's actually not that hard of a number to ingest if you spread the payment out over 3 or 4 years.
So I think I was making this statement, just probably didn't articulate it very well, but if everybody starts going directly to the plaintiff's lawyers and cuts their own deal, then that starts to degrade that ability for NAR to do it, and it potentially could harm their membership numbers even further. Yeah, in theory. All right, so
just to put a bow on that, so basically every settlement, for example, Remax and Anywhere, and every copycat lawsuit only makes this more complicated and harder to settle for NAR, correct?
It does, but it's not impossible, and it's still, in my opinion, a case that can be settled.
Yep.
But it has more nuances to it. There's more plaintiff lawyers that have to be brought under the tent to agree to things. So, but those things can happen, right? Cases can get consolidated and put into the front of the same judge.
The benefit is it is also, and I'll spare everyone a lawyer joke, but the benefit to this is, candidly, what the lawyers care about is getting paid and defending their clients, right? But what the lawyers care about is getting paid. This is a way in which, this is the cleanest way, the simplest way for the plaintiff's attorneys to get paid and to put all this to bed, correct?
So I'm going to say the second part of that is correct, but please don't dismiss the fact that plaintiff lawyers want to effectuate change. Yeah,
for sure. Yes.
It's a tripe that people say the lawyers only want the money. I can tell you, as a plaintiff lawyer, in doing construction defect litigation, in almost every case I ever had, we took less money in fees than we had to, because I wanted to make sure my client could fix the things that had to get fixed.
For sure. I guess I'm sort of just accepting that change is going to happen, which I shouldn't. You're right. Yes. You're right. I shouldn't just surrender that point. But in my brain, the changes are already coming. And so then it's really just figuring out what's the best way to pay for this.
You're correct. Once the changes happen, whether that's through this injunction process or NAR settles the Sitzer case and agrees to a rule change so that the rule change is not in play in any of these other cases, then yes, then it's only about, locking down the money situation and how do we solve that problem. Honestly, that's not hard to solve. It's expensive, but it's not hard.
All right. So I want to make sure we get a couple things answered while we got you here. So number one, are there going to be more copycat lawsuits? And I'm prefacing that with, I keep hearing people, and it's driving me completely bonkers, like in California, where they're like, we have good farms, we're protected. I'm like, that has nothing to do with, stop with your nonsense. That has nothing to do with it. So can you, are there going to be more copycat lawsuits is my first question. Do you think we've seen the end of it?
I don't know that answer. There
as a plaintiff's lawyer,
but they're just going to get consolidated into the existing cases. This idea that your form protects you, that's kind of cute, but that's not how conspiracies work. And I think we've already demonstrated that.
It was like the form in Missouri is very clearly laid out how things work, and that didn't happen. So, yeah.
Right. I mean, it's cute that the form says in 15 different places in big, bold letters, everything's negotiable. But that piece of evidence gets weighed against the evidence of a jury hearing, how your agents are trained, and how the 3 agents I interviewed all came in and said, if you don't put the number I already pre-printed on your form as a offering compensation, no one will show your property. That's also evidence, right? So you have these competing pieces of evidence. And I think we've seen already how juries will react to the fact that, so great, there's a sentence on your form that says it's negotiable. But the reality is, when 3 people stand in my living room and tell me if I don't offer a certain number, people aren't going to show my house, that's also evidence.
Right.
And the jury gets to pick which of those 2 they're going to go with.
Right. Okay. So I want to make sure we get 2 questions in here, and I'm going to keep you held to the time on this so we can get them done. Because the first one is going to be about explaining the Batten cases. I want that because people are asking questions around this other this other case. So I want to spend like 4 minutes on that.
Okay.
And then I want to spend 4 minutes on what a structure, I want to end it with what I think is a positive. Like, what would a structure of a settlement look like? Okay, so let's start with the Batten former leader cases. So
right. You can tell James is not paying me on the clock because I would never do an explanation for 4 minutes.
I know. I was about to remind you that we're not on the clock. So yeah,
we'll see what we can do here.
Yeah.
Okay. The Batten cases. Sometimes the first Batten case was originally called leader. It's a buy side claim. So this is a whole different group. And the argument here is that the buyers are actually the ones that paid the commission. There is an argument here that this is true, right? That the buyers are the ones who came to escrow or the closing with a check. They're the ones who ended up paying the buy side commission.
Sure. Yeah.
They did not get to participate with the system that we have, with the seller and a listing agent deciding how much is being offered to the buy side in a transaction. The buyers never get to negotiate that. And even if they do negotiate it, the argument was, what happens to the spread? Does the spread get held by buyer agents? And there are places where that's kind of occurs. So that's the buy side claim. Now it's a giant number because, and this is kind of ridiculous, they're arguing that it goes all the way back to 1996 because they're saying, hey, if I have a 30-year loan and I paid an extra $15,000 over interest for 30 years, that's my damages. Now, we all know nobody pays their loan off in 30 years, right? These kind of things. But anyway, that's their damage number. So that's a different nuance, a different side of what's happening. Now, there's this new thing called a Batten 2, which is they just updated their filing. It's a very good filing. It's a good complaint. They deal directly with the indirect purchaser challenge, which is what they have that I talked about earlier. Because the concept there is the buyer a purchaser of services in that situation, right? So there's a lot of nuances on there, but it does add a layer of complexity to the extent that now we have to resolve the buy side commission and those lawyers as well. So that's definitely makes it more complex.
Is there some precedence that this is a weak case in that the sellers, a jury just found that the sellers were the ones that were damaged? And I think am I the only one that finds that strange? Like,
usually one party that was damaged, not everyone.
That's exactly correct. And remember the Morrell case that's in Northern Illinois, it's the same judge that has these Batten cases. So, or at least Batten 1. So she understands that. She has to weigh those two issues against one another. So that comes into play. I think there's also an argument of, what do you do with buyers who signed a buyer rep agreement? They can't argue they didn't participate in negotiating it. That's part of the buyer rep agreement, right? So is your class, only buyers who didn't sign a buyer rep agreement, right? So there's a lot of nuances there, but it definitely adds a layer of, again, additional complexity and an additional layer of people who have to be involved in the discussions of how are these cases going to resolve.
Well, if you do a mass settlement on the sell side, there's no money left to do the buy side. Like, I mean, do they all?
Or there is, or you bring them into the same conversation and we say, here's how we're splitting the money.
Yeah. Right. Okay.
Was the initial settlements for Remax and Anywhere, did that include?
Nope.
Gotcha.
Nope. That's sellers only.
Yep.
So Remax and Anywhere can still get sued in Batten on the concept of the buyers were damaged.
Yep.
All right. Talk to us about what you think a settlement proposal might look like, or I mean, I know you're very involved in this industry and stuff. So like what is it you think that would look like as a way to start the process?
So when you say settlement, you want me to focus on injunctive relief and what a rule looks like versus the money?
Sure. Like, what do you? Let's talk more about how do we get this moving in the right direction. Let's just start with that. Like to get us down this road. Where does this start and begin? So
I think the most important thing that we need to focus on as an industry, and however that resolution can happen, would be making sure that it is easy for buyers to receive quality and good representation, and to be able to pay a meaningful market rate that the buyer negotiates. Okay. And the path I see for that is we can live perfectly fine in the multiple listing service without a formal offer of compensation or a unilateral offer of compensation in the MLS. You just get rid of the box. Okay. Where that's offered. I do think there is a high level of value in what I call concessions in price, right? A box that's just free form text. It's not an offer. from the seller saying, I promise to pay this if you accept. It's simply a communication tool that says, in this list price, I, the seller, say, I'm willing to contribute 1% towards a loan buy down or a rate buy down or a 2-1 buy down. Or I agree to put a credit for $5,000 because the floors need to be replaced and I want you to pick the color of the carpet. And I think that's a better mechanism for me as a seller to communicate that to buyers as far as that opportunity or other kind of repairs. And I think one other thing they could do then would be say, hey, this price anticipates or includes me providing you with a certain percentage to contribute towards the payment of the buyer's fee, the buyer agent fee. Now, at the same time, I think we need some other rules. I think you need to get rid of 1616, standard of practice in the Code of Ethics, which is the rule about, you can't use a negotiated, the buyer's agent can't use an offer to purchase to modify an offer of compensation from the listing broker. Well, all of that is irrelevant now. That's not in play anymore if you get rid of the offer, right? So just get rid of 1616. And you just make the negotiation for what the seller is going to contribute to pay for a buyer's fee, just like you would any other negotiation in a transaction. I think there's one other important element that needs to be added, and that is we already have an Article 7 that says, as an agent, as a realtor, you are not allowed to collect money from more than one person in a transaction. That's already our rule, unless you have informed consent from your clients. And that's really what a buyer representation agreement is, right? A buyer representation agreement says, hey, Keith, if I represent you as your agent, Keith, you're going to pay me a certain fee that I'm going to charge you. And it goes on to say in that representation agreement, when we make an offer, if I get money from anywhere else, from the seller, from the listing broker, from any other source, I'm going to credit that as if you paid me, and that lowers the amount you owe me. So we already accommodate that in the current system. What I would add is a standard of practice that says the buyer, number one, buyer representation agreements need to be signed before you show a property, right? That should be an addition to standard practice 9. That should be an MLS rule. We should never let somebody into a house if they don't have a written representation agreement with the client that they're walking through. I argue that's already under Article 9 of the Code of Ethics, okay? People don't believe me on that though. But anyway, so assuming that you're getting a buyer rep agreement signed before you ever show a property, we should have a standard practice 7.1 that says that a realtor can only receive the amount in commission or compensation that is in a written agreement. Right? The idea here is if I'm representing Keith at 2%, yes, I'm going to use numbers, and if someone wants to sue me, have at it. Right, James is offering more than that. The concept is, Keith, look, you're giving me 2%. That's what I'm getting. That's all I'm getting. Mm-hmm. James has communicated in this concessions and price field that his current list price anticipates, a higher amount. What, Keith, do you want to do with that? Let's talk about offer. We can lower the price by that differential.
Yeah.
And it's still, from James's perspective, that's still a full price offer.
Right.
Because Keith, you're the one who agreed to pay me the percentage that I'm getting.
Sure.
Right? Or do we want to take some of what is in that price and apply it to a loan buy down? Or do you want to apply it to some other kind of closing costs or credit?
Mm-hmm.
Yeah.
Right. Depending on what kind of loan you're getting in your lender. Right. So what it allows us to do as buyer agents is to assist the buyer in communicating and formulating an offer that takes advantage of whatever the seller has included in concessions. Again, whatever the concessions are, this doesn't have to be limited to
comp.
Comp at all.
Could be anything. Yeah.
And the good thing is too, right now, what you see is this offer of credits inside of agent comments. Mm-hmm. Right, which doesn't go out the door. Right, it doesn't go out to the public because it's in a field that's tied with other things that are more private. And so by making it a separate field, we could send it out on IDX. We can put it in consumer.
Make it public. So it's transparent.
Yeah, very transparent. The buyer sees this concession amount and helps him formulate where to make an offer. So you're incentivizing the buyer, not the buyer's agent. And there's no chance that the buyer's agent would capture or benefit from any differential, because we would have rules and code of ethics that prevent that from happening, that you can only get the compensation that is part of the written agreement you signed. And that way, any differential, any overage has to either go back to the seller or back to the buyer. Not to the agent.
So to summarize here, we have decoupling. We have a change in the field. I'm simplifying, but in the MLS where you can offer anything you wanted to in that. That's what the plaintiffs are looking for anyway. Like there's this decoupling. Yep. There's still the ability for the seller to do whatever they want in order to incentivize a buyer or make offers to the buyer. We have a buyer broker agreement that's signed, and I agree with you, before property shown. Makes complete sense. 12 states to some degree or another in that process currently. Washington's now be 13 in January.
So we know it works, by the way. For those people who argue against it, saying, "Oh, that's not possible," guys. For very long periods of times and tens of thousands of transactions, people have lived with signing buyer rep agreements before showing a property.
Okay. All right. So last parting words before we got to run and wrap up here. So I guess, where do you give us a minute of where does this go over the next 30, 60 days? What do you just forecast?
It's hard for me because I'm not involved in the, setting the policy.
Pretty damn good crystal ball so far. Yeah.
But my recommendation would be for NAR and maybe the remaining corporate defendants to negotiate what the rule is going to be. I think as an industry, that's by far the best thing they can do for us right now, is let's stop the what's going to happen next. Let's participate as industry professionals in what the solution is going to be as far as protecting consumers, upping the transparency game, making sure that buyers are involved in negotiating the buy-side fee. At the same time, making sure we keep it easy to buy and sell a property so that buyers can get into homes. And I think I'm most concerned that if people who are 2, 3, 4 steps away from the industry start writing those rules, that they may not appreciate the nuances and
the long tail effects, right?
The home buying opportunity, and that's not good for buyers or sellers. So that's that would be the thing, and the money thing can be worked out, right? That to me is a later thing.
Focus on the rules. We'll let the money thing sort itself out.
Get the rule tied down.
Ed, thanks for being here again. I just learned a lot as usual. And we'll have you.
We'll have you on in a few weeks, but not on retainer. Not on retainer, but another invitation.
Right. Well, just some good news, right? Hopefully it'll be to comment on this cool new rule that we have and how to make it work and steps that we can take to implement a great solution in front of us. That's what I'm hoping I come back and talk to you guys about next.
And just in case anyone wants to listen to the first half of this conversation that we did, it was episode 27. You can go back, and that was a few weeks ago, several weeks ago, but some of what we've referenced here, we go into greater detail in that conversation.
Great.
All right, my friend, we'll have you back soon enough, I'm sure. So appreciate you.
Thanks.
All right.
You guys take care.
Thanks. Thanks for joining us on the podcast. Hit that subscribe button. Trust us, it's the best thing any of us will accomplish today.